The moment you do not appear in court on a scheduled DUI date, the judge will typically issue a bench warrant right then and there. A bench warrant is a court order authorizing law enforcement to arrest you wherever they find you. It does not expire. You can be stopped for a broken taillight a year from now, and the officer will see that warrant and take you into custody. Missing court does not just leave you with the original DUI. Under Penal Code 13-20, missing a misdemeanor DUI court date can add a separate misdemeanor failure to appear charge. If your DUI is a felony, the failure to appear can also be a felony. Where you once had one case, you now have two, and the prosecutor's leverage over you increases significantly. Two other consequences hit quickly. First, the court notifies the DMV, which can impose an additional license suspension on top of any DUI-related suspension already in place. If you were counting on a restricted license to get to work, that plan can collapse fast. Second, if you were released on bail or on your own recognizance, the court can revoke that release, meaning you could be held in custody while your case resolves rather than fighting it from home. Judges and prosecutors have long memories. Walking back into court after a bench warrant is not the same as showing up on time and engaging properly with the process. Outcomes like a reduction to a wet reckless or access to alternative sentencing depend partly on the court's perception of you as someone taking the case seriously. A failure to appear undercuts that perception before you even speak. The single most important step is to contact a DUI defense attorney today, not next week. An attorney can file a motion to recall and quash the bench warrant, and in many situations, appear on your behalf under Penal Code 977. Courts do grant these motions, especially when you act quickly and come in voluntarily rather than being picked up on the warrant. Also keep the DMV side in mind. Your criminal court date and your DMV hearing are two separate proceedings, and the confusion of a warrant situation often causes people to lose track of the 10-day DMV hearing request deadline entirely. Acting quickly gives you far more options than waiting does, and results vary based on the facts of your case, the court, and how the situation is handled from this point forward. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.